As the chief executive, the president is supposed to enforce the law. But what happens when the president violates the law? The president enjoys two prerogatives that make it very difficult to detect or punish wrongdoing by a sitting president: executive privilege and presidential immunity. Neither of these doctrines is mentioned in the Constitution. They were both created by the Supreme Court, and they both had the potential to be abused by a lawless president. This video discusses executive privilege. Executive privilege is the right of presidents to keep certain things secret. While he was investigating the Watergate scandal, Special Prosecutor Archibald Cox discovered that Richard Nixon operated a secret tape recording machine in the Oval Office. Realizing that these tapes could be valuable evidence for his investigation, Cox issued a subpoena to Nixon, seeking to force him to turn over the tapes. Nixon initially refused to do so and challenged the constitutionality of the subpoena, a dispute that eventually reached the United States Supreme Court in U.S. v. Nixon in 1974.
In the short term, the decision was a major loss for Nixon. The court decided unanimously that he was required to turn over the tapes. These tapes contained proof that Nixon had been an active participant in the cover-up, and he resigned a mere 16 days later. But the decision was actually a major win for the presidency. Although the court did force Nixon to turn over the tapes, they agreed with his underlying argument that presidents possess something known as executive privilege, which permits them to keep things secret under certain circumstances. The court said there are two reasons presidents might legitimately want to keep secrets. First, discussions regarding national security often involve classified information or other information that shouldn't be exposed to the public. Second, presidents have an interest in receiving the best advice possible from their advisors. The court said that the president has an interest in candid, objective, and even blunt or harsh opinions. A president and those who assist him must be free to explore alternatives in the process of shaping policies and making decisions, and to do so in a way many would be unwilling to express except privately. In other words, advisors might censor themselves if they knew that their internal deliberations would be exposed to the public. The interest in candor sometimes justifies shielding internal deliberations of a presidential administration. In a later case, the court extended the privilege to the vice president as well.
While the court confirmed the existence of executive privilege, it is not absolute. Nixon, for example, lost partially because the discussions did not include national security. In addition, the court said that the president's interest in receiving candid advice must be weighed against the needs of the criminal justice system. They wrote, "The very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts. The allowance of the privilege to withhold evidence that is demonstrably relevant in a criminal trial would cut deeply into the guarantee of due process of law and gravely impair the basic function of the court." It is important to note that the Nixon decision was limited to criminal investigations. One of the main functions of Congress is to oversee the executive branch and make sure that it is operating effectively and within the law. The court explicitly said its decision did not address the issue of whether executive privilege applies to demands for information from Congress, and it has never specifically addressed the issue since then. As a result, presidents have sometimes used executive privilege to stymie congressional investigations.
Presidents are far more likely to be the subjects of congressional investigations when the opposite political party controls at least one chamber of Congress. Until recently, formal claims of executive privilege have been relatively rare. For example, George H.W. Bush, Barack Obama, and Joe Biden each only formally claimed executive privilege once in their tenures. The president who had claimed it most frequently was Bill Clinton, who claimed it 14 times during his 2 terms in office. As in most things, Donald Trump has challenged conventional norms. In 2019, Special Prosecutor Robert Mueller released his report on Russian interference in the 2016 presidential election. Soon thereafter, President Trump announced that he would refuse to provide any information to any congressional investigation into the matter. He also refused to cooperate with the congressional investigation into his decision to withhold aid to Ukraine, a refusal which ultimately led the House of Representatives to vote to impeach him on charges of obstruction of Congress. Trump's opposition to congressional oversight has been unprecedented in modern history, and his aides are willing to go to prison for him. Two of his advisors, Steve Bannon and Peter Navarro, refused to comply with congressional subpoenas despite not being covered by a claim of executive privilege. Both served time in federal prison after being convicted of contempt of Congress.